Yes.
My Lord, I was seeking to address before the short adjournment what we in our submission say are some of the advantages of the representative action.
Yeah.
And my next point is that those are legitimate advantages of efficiency and access to justice, which are of particular importance here. And the first point to be made there is that in large listed companies such as the Defendants here, there are or will be many investors whose holdings are modest in size, either in absolute terms, such as for a retail investor or a small institutional investor, or in relative terms, for example, for an institutional investor with a diversified portfolio. And the evidence here supports that. In footnote 5 in Mr. Leadham's witness statement, in the supplemental bundle 1, tab 5, page 87, he tells us that from the Defendants' 2019 annual reports, it is evident that for Reckitt, some 11,500 odd of 17,000 odd shareholders were individuals, so something in the order of 68%, with the remainder being nominees and institutional investors. And for Indivior, a little over 10,500 of 11,875 shareholders, or 89%, were individuals. And self-evidently, the claims, if they have them, of the smaller investors are as good in law as those who have larger holdings and who either have the means or the funding to pursue claims through alternative means. And there is no reason in our submission why those smaller investors and their claims should be treated differently, such that for practical purposes they are unable to bring those claims forward or to obtain redress. And a point that we make is that on the evidence, although it's self-evident, whether a smaller institutional shareholder or a retail investor, the investor has to undertake a cost-benefit analysis as to whether the time, money, and effort and risk of joining any given set of procedures is worth it. And it's that type of issue and concern and potential limiting of access to justice that, of course, we say Lloyd set out to address. Now, we do say on the evidence here that it is clear that for smaller shareholders, be them smaller institutional shareholders or retail investors, the game is not worth the candle if the multi-party procedure is employed, or at least that's very likely to be the case. And we say that for essentially 4 reasons. The first is that is clear as a matter of what my Lord the Chancellor described in the Le Patarel and British Telecom case as judicial common sense. If it was commercially rational for smaller investors to bring their claims, and in particular for commercial funders to fund them, then they would do so. Here we know that they are not doing so and are not prepared to do so. Second, but relatedly, we do know that no other Section 90A claim brought to date, so brought in the 15 years since such a claim has been available, has included retail investors among the claimant group. And picking up on a point made to me this morning by my Lady Justice Falk. That's unlikely to be because retail investors, all of them, have particular concerns about satisfying the test for reliance, or indeed any of the other elements of the cause of action that they need to make out, as against institutional investors who have brought those claims. The more natural explanation of the position is that those claims have not been brought by those investors because they have not been viable to bring. Now, third, that brings me to the evidence here in this case, which is to be found, first of all, in Mr. Leadham's statement at paragraphs 30 to 34 in the Supplemental Bundle, Volume 1, Tab 5, page 86. And what Mr. Leadham does here is he first of all identifies, as I have just done in summary, for example, at paragraph 28 on the preceding page, the characteristics of the institutional investors who have joined the Section 98 claims that have been brought to date. And then in paragraph 29 identifies that none of those claims have been brought as representative actions, and identifies instead some of the features of the multi-party proceedings and case management orders that have been made. And then starting at paragraph 30, he sets out his evidence that that approach, the approach adopted in the multi-party proceedings, which he says requires the claimants to perform significant work in advance of any finding of liability on common issues, has serious ramifications for the participation of institutional investors in securities litigation in England. And then he sets out in his experience and the experience of his firm why that is, the following sub-paragraphs, which I'll just invite the court to read, if I may, please.
Yeah.
And so one sees there some evidence given by reference, including to the costs, both actual and anticipated in G4S and Serco, as to the costs of pursuing the multi-party proceedings. He then refers to the evidence of Mr. Lang, to which I'll turn in a moment, about the position of other institutional investors. Before paragraph 32, turning to the position of small institutions and retail investors, where you'll see that he says that the burden on such persons of instructing lawyers, particularising limitation, reliance and loss, undertaking a disclosure exercise and providing factual evidence where the court has not yet made a finding of liability, is a very powerful disincentive to participation, notwithstanding that they may have strong prima facie claims. Then at 33, he deals with disincentives also applying to the claimant's own costs of security claims, whether self-funded or funded by litigation funders. And concludes at the end of paragraph 33 by saying funding is of course central to the viability of these claims because very few, if any, individual investors will have suffered a sufficiently large loss to be economically viable to pursue and therefore to be funded on its own, i.e. without being grouped together with the claims of other investors. And then at paragraph 34, he makes the point, which I've already made too, about the other Section 90A proceedings, none of which have featured a claim by retail investors. And he goes on in that paragraph to make the point about access to justice for retail investors before drawing the contrast with the bifurcated Lloyd representative type action, where he makes the point that it would be economically viable to fund such claims in the second stage of a bifurcated 19.8 scenario, as by then the incremental cost will be lower and funders will have more confidence in funding such claims when liability has already been established. And their liability, again, is being used in the shorthand, as I explained this morning. Now, that evidence is to be supplemented by some explanations that were given in correspondence as to the position of the retail investors who had joined the representative action but not the multi-party action in this case. And could I invite the court to turn up, please, Supplemental Bundle Volume 2, tab 26, please, at page 459. This was the week prior to the hearing before the judge below, a letter of the 9th of November providing an update. And on the second page of the letter, page 460 of the bundle, paragraph 7, first of all, an example copy of the cost sharing agreement is referred to and provided under copy of this letter. And then at paragraph 8, what he said is that any investor in your client's ordinary shares during the relevant period that would fulfil the definition of a represented person is eligible to participate in this action, regardless of whether that investor is a large or small institution and or a retail investor. Retail investors are therefore eligible to become represented persons if they fulfil the definition. A modest number of retail investors have requested to become represented persons in recent days and weeks. They have done so only on the basis that the action is permitted by the court to proceed as a representative action, and they are not therefore claimants in the multi-party proceedings issued against your clients. And then there's reference to separately providing an updated list, which was provided, of the represented persons. We expect the number of retail and other small investors to grow significantly if your client's strikeout applications fail and the action proceeds as a representative action, which is a reference to the point, again, I addressed the court this morning about this not being a closed class and a class where if the representative action, if the representative action were permitted to continue, the expectation is that greater investors would join it. And just for completeness, at paragraph 10, there's the reference to providing trading data of the represented persons on a without prejudice basis. I think I indicated that had been offered. It had both been offered and indeed provided. And the final piece on this is at tab 30 in the same bundle, page 501, a further letter from Mishkondarare, this time of the 16th of November, in answer to a letter of the 16th of November 2023, which appears behind the preceding tab. And at paragraph 3, one sees that the answer to the question, hence your follow-up questions, is no. So to see what the question is, one has to go to the preceding tab, tab 29, page 499. And the question appears at the bottom of page 499. Please confirm whether the retail investors recently added to the representative actions were given the opportunity to join the equivalent multi-party actions, and if so, whether they were given the opportunity before the multi-party claim forms were issued, and whether they were given the opportunity to do so on a similarly funded terms, noting our understanding that Woodsford is funding both claims. So that was the question, and the answer was no. The retail investors were not given the opportunity to join the multi-party Proceedings, and the answer goes on to say, as is made clear in our client's skeleton arguments and consistently with the position of all funders in the market so far as we are aware, Woodsford is not willing to fund retail investors to participate individually as parties to litigation in a multi-party action brought under Section 90A FSMA. This is because the multi-party route is not, as a matter of economic and administrative burden, worthwhile pursuing for such investors for all the reasons which have been explained in evidence. Those burdens apply not just to the funder, but to the retail investors themselves.
But to be clear, it's a decision of the funder.
It is a decision of the funder not to advance funding to those smaller investors, yes, other than to become represented persons in the representative action.
And as I understand, I'm not sure, don't think you've taken us to it, but even in the representative action, that's only on terms.
It is on terms of the cost sharing agreement, which we can look at. It's behind tab 26 in this bundle at page 462. This is an example of the cost sharing agreement. And just to pick one or two of the clauses out. Paragraph 3 provides for cost sharing. Paragraph 4, the representative claimant and the represented persons are provided for their liability and or potential liability for action costs and adverse costs via a combination of litigation finance and after the event cost insurance. Clause 6 deals with the requirement that represented persons will provide to the solicitors for the representative claimant accurate and complete trading data, which is a point I think I made reference to earlier this morning. And that's picked up in paragraph 11. And then paragraph 12 provides effectively for the filter, as I described it this morning, that the solicitors need to determine that the third party who seeks to become a representative person has a reasonably arguable claim for loss caused by the defendant.
How does it do that? It's got the trading data.
That's right.
Which presumably tells you rates of purchase, sale, numbers of shares.
It will do that, yes. But that is subject to compliance too with the obligations in clauses 14 and 15. And that they deal with meeting a liability for action costs and adverse costs. And the relevant clause is clause 14, which requires a third party that wishes to become a represented person at will, unless otherwise agreed by the representative claimant, for example, because the third party has put in place other funding arrangements acceptable to the representative claimant, pay to the solicitor's client account the amounts referred to in the clauses that follow, and those are the provisions requiring, absent an acceptable funding arrangement, a contribution towards costs. But what's important in that clause, and seems with respect to have been slightly glossed over or overlooked by the judge, is the unless otherwise agreed by the representative claimant, and then the example given, for example, because the third party has put in place other funding arrangements acceptable to the representative claimant. And we know from the documents that we were just looking at that the litigation funder had been prepared to provide litigation funding to retail investors for the representative action, but not for the multi-party action.
I
Now,
may have misunderstood this. Are you saying that in relation to the representative action, it falls, retail investors have in practice fallen within the unless otherwise agreed carve out?
yes, because
So they have not had to provide
my lady, correct.
protection
Yes,
referred to here.
because as we've seen just now, the litigation funder is prepared to fund them, but only to fund them as represented persons, and not in the multi-party action.
Do we have an explanation from the funder as why that is so?
Not from the funder.
And nor do we have any evidence to actually substantiate the point that's just been made by my learned friend.
Sorry?
Nor do we have any evidence to substantiate the point that has just been made by my learned friend.
Well, other than with respect, the evidence that we've just been looking at, to the effect that the funder is providing funding to retail investors to become represented persons.
Where's the evidence of that as a matter of interest?
So that was in the correspondence we were just looking at.
Which bit of it?
At in particular, the letter of the 16th of November at tab 30. So that's the explanation as to why.
But that's an explanation as to why they're not parties to the multi-party action.
You say it's paragraph 4 of that then?
Paragraph 4 is
Considered appropriate for funding.
appropriate for funding.
Yes, yeah.
Okay, so are we to take, you say we should take from that that means the funder's willing to fund them and therefore they do not have to provide guarantees or costs in advance?
My lady, yes. And that
But we don't have that level of detail.
you don't have that. You don't have that in evidence from the funder, no.
Do we have
Or from
any
the individuals.
idea of the total quantum of the claim? Is that in evidence anywhere?
I will have to check. I think Mr. Leedon does give some evidence as to that.
Because when we were looking at the cost sharing agreement, tab 26, you skipped over paragraph 7, which is what tells you how much each claimant, as I understand it, is liable for. You take the total aggregate estimated loss,
Yes.
and then you look at each investor's aggregated loss, and that gives them their share. And the result of that is that if you have institutional investors who've invested millions of pounds on the one hand, you have retail investors who've invested hundreds of pounds on the other, the liability for costs of the retail investors is going to be tiny. I mean, a matter of a few pounds. Is that right? Have I understood that correctly?
The information provided pursuant to clause 7 will give you the estimate of the total quantum, which we don't have to include the retail investors because the retail investors join the represented class.
But although there are 200 odd retail investors, their total quantum is likely to add up to only a tiny fraction of the total aggregate estimated loss.
Yes, that must follow. Forgive me for interrupting a little, but at the moment, of course, the anticipation is that if the represented action is permitted to continue, then many more.
But there will still be very small amounts. I would find it helpful to have put some sort of real figures on this. I mean, if the aggregate estimated loss is, I don't know, 500 million, and you've got 200 retail investors each of whom have invested no more than £10,000, then the total of the retail loss is only going to be £2 million, which is a drop in the ocean compared to the 500 million institutional loss. And if their liability for costs is proportionate, then even if you spend £50 million on the litigation, they're still only going to spend a few £100,000 between them, which means their individual liability for costs might be £1,000 each. Now these are, these figures are all wrong, but the scale is not, I think, wrong, which means that the actual cost to the individual retail investor of joining this litigation is tiny, isn't it?
Well, assuming for a moment that the example is correct, and I'm obviously prepared to do that, the question is whether on a cost-benefit analysis they are prepared to incur that cost if this were to be available for the multi-party action. Of course, this cost-sharing agreement is only being made available for the representative
I
action.
understand that's the evidence, but I've not understood why. I mean, this is the difficulty I'm having, is that I understand that if retail investors were expected to fund an equal share of the litigation, then it might well not be financially viable to them to join the multi-party litigation. But if they're being asked to pay a proportionate share, then because even though there are 200 of them, the aggregate amount of their claims is likely to be so much smaller than the institutional claims that the actual costs risk they are taking on in joining the multi-party action, if funding was made available on the same terms, would be tiny. Have I misunderstood that?
My lord, it's the if litigation funding were to be available on the same terms.
Yes, well that's why I asked it. Do we have an explanation from the funder as to why they're not prepared? I mean, we have evidence that they're not prepared to do it because you've shown us the letter.
Well, that's in Mr. Leadham's witness statement where he explains why it's not economically viable.
I just don't understand
That's,
why
that's
not.
what I've not understood.
No.
I mean, that's
I
what
don't understand why it's not economically viable.
Well,
Because ultimately, if you're right about everything, you're going to incur these costs at some stage, come what may.
but only in light of the declaratory findings and likely in more streamlined economic proceedings. But the point is that the individual costs of administering these small claims, given the deterrent factors that Mr. Leadham identifies in the paragraphs of his evidence, to which I took the court a moment or so ago, have the effect that the funder is not prepared to offer these funding terms in the multi-party proceedings in the way that it is prepared to offer that funding in the representative action. And the proof of the pudding in that regard, not just from the position in this case, it is seen from the absence of any retail investors in any of the other funded claims under Section 90A. And I sort of come back to the point as to the natural inference that falls to be drawn from that. If funders, acting rationally and in their own, frankly, commercial interests, thought it was in their interest to fund the smaller investors' claims in those proceedings, then they would be doing so. And they do not consider it economically viable to do so for the reasons that Mr. Leadham sets out. And by contrast, here you have the first attempt ever to bring such a claim under the statutory regime by way of representative action. And there are retail investors, currently 200 odd, responsible for 300 or so claims, and who have available to them funding because of the distinction between the two sets of proceedings to which Mr. Leadham referred.
Do we know what the RBS proceedings were? Because that involved retail investors.
It involved retail investors, but was not a Section 90A claim, and it was a prospectus claim under Section 90. So reliance wasn't an element of the cause of action, and so the type of front loading of costs to deal with the claimant-specific issues that we have in Section 98 claims, and to which Mr. Leedham refers, were not present in that case. And that's why you really have this quite stark position. Yes, there were some retail investors in that case, but if you actually look at the other Section 98 claims, there's not one, not a single retail investor in any of those claims, or all of which were funded claims.
Because they might be asked to fill out a questionnaire.
No, because they might be asked to demonstrate what the statute requires them to demonstrate, which is reliance.
Well, and there, my lord, in fact, you might think that an individual retail investor who was making their own investment decision to invest might be rather better placed to show reliance and have better recall and everything else than an institutional investor.
No, does one?
I'm sorry.
We just don't know that at all.
Well, but what my lord,
Or you Mr. Leedham says, well, it's retail investors haven't participated in other Section 98 claims. We don't know why. We don't know if there's a particular reason for that. We don't know if they've been put off by something, whether other funders haven't been prepared to fund.
well, you have Mr. Leedham's
It's all
evidence.
very speculative.
But my lord, with respect, one can look at the probabilities.
How long was it before the hearing, before the judge, that this all emerged? About 3 weeks?
It was in predominantly it was in the week before the hearing.
Yeah.
Because the retail investors became members of the represented class relatively late in the day, and that's why the update was provided. And that also explains why the position of the particular retail investors is not addressed as fulsomely as we might like, as anyone might like, in the evidence that had been filed before, so to speak, they joined up. But one has to look at, in our submission, the probabilities, which the judge didn't. We know, and it's not in dispute, that no retail investor has been a member of any of the groups in the other Section 98 multi-party claims. And in our submission, if that was to deal with a problem with the cause of action, you'd at least see some. But to see none is really quite remarkable in our submission. And the much more likely explanation as to why we see none is a combination of them concluding on a cost-benefit analysis that it doesn't make sense and is not worthwhile for them to self-fund. And as Mr. Leedham tells us, from his knowledge of the market and those other claims, the funders have not been prepared to fund them as they have the institutional investors. And when I ask the court to look at what the likely probabilities are, one might add to that, it is of course always difficult to prove a negative, to prove why it is that someone is not participating. But one can look at, and we say must look at, the fact of non-participation. Retail investors do not appear in any of these multi-party proceedings. Not a single. Now, as for the position of institutional investors with smaller holdings, that is addressed in the evidence of Ms. Mendoza of ISS and Mr. Lang of FRC. Their evidence is at tab 6 and 7 of the Supplemental Bundle Volume 1. And it is to similar effect. So starting at tab 6 and Mr. Lang, he addresses how his clients, institutional investor clients, decide whether or not to join shareholder claims in various different jurisdictions, and he sets out some of the particular concerns that he describes in paragraph 32 as being especially strong for UK efforts. He refers at paragraph 35 to the burdens in UK securities litigation typically being more onerous. And at paragraph 38, the fact that work is front-loaded during the proceedings is a particular disincentive for participation. And he draws a distinction between the position there and the position as it would be under the representative action, as we say, is likely to be here in paragraph 39, where participation is greater or more likely once wrongdoing has already been established. Now, in terms of that translating into a statistical analysis,
to what extent does he cover the point that uptake after the first trial is associated with, he didn't use this language, but effectively an expectation of settlement?
I don't.
You touched on that earlier. I think we may have discussed it in the context of limitations.
Yes.
Afterwards.
Paragraph 39 certainly does not deal with that issue in terms.
Because just coming back to the fact that you've got these litigants in representative proceedings without their own proceedings, who may at least be taking a risk on limitation, yet nevertheless join the representative proceedings.
Yes.
You can see that a rational actor might think, well, there could be a really high chance of settlement after the first phase, and therefore perhaps I don't need to worry so much about the limitation issues, because otherwise it does seem somewhat odd that claim forms aren't issued.
Well, I think the best I can say is that may be another explanation. Of course, we say another explanation that flows from everything I've just been saying as to why claim forms are not issued to protect against limitation is because of the cost-benefit analysis that is struck.
Yes, but the funders would have the funders are affected by the limitation point as well, aren't they?
True. And they've obviously taken a view that they have. Yes, in terms of the statistical comparison, at paragraph 49 and 50, Mr. Lang gives evidence as to the greater participation in other jurisdictions when compared to the United Kingdom, and in particular by reference to Australia. And one sees from his chart 2, he sets out some statistics in terms of client registrations per case by country, where he has 12 FRT clients register for Australian securities claims compared to an average of just over 2 in the United Kingdom. Now, that pattern is reflected also behind the next tab in Ms Mendoza's evidence. And as I've indicated, her evidence is really to like effect as to the disincentives of the English multi-party proceedings. And indeed, she agrees with what Mr Leedham says about that. If reference is made to paragraph 24 of her statement at page 122, and indeed paragraph 25, and having identified and agreed with effectively the same disincentives that Mr. Leedham speaks to, she too then provides some statistics from which we see at page 122 and then over the page with the chart at the top of 123 that while just over, for example, 78% of her clients with potential claims in shareholder actions in New Zealand sign up, and just over 61% for Australia, when it comes to the United Kingdom, the proportion participating drops to 29.4%. And that then flows into her conclusion at paragraph 31 as to participation being likely to increase if a representative claim is to be permitted. So, stepping back and looking at the position in the round, if it was commercially viable for smaller claims to be brought, you would expect to see them, either because the investors themselves consider it worthwhile to do so, or more likely perhaps because they would obtain funding to do so. We know that's not the case, generally, and we know that's not the case on the evidence here because of the disincentives to which Mr. Leedham speaks and which are echoed by Mr. Lang and Ms. Mendoza. Equally, by contrast, we know that so far hundreds of retail investors have been willing and able to become represented persons, and a funder is in principle willing to provide the funding for them to do so. And that in itself, in our submission, is evidence that the use of the CPR 19.8 representative action procedure is providing access to justice for those smaller investors in a way that the multi-party proceedings do not. Now, we've set out in our skeleton, I won't repeat it now, that pattern and overall position is supported by the evidence from the other jurisdictions where the bifurcated approach has been adopted, which is addressed in some detail by Professor Higgins in his report. And perhaps just one point to address orally to those that we've made in writing, and perhaps a telling one, is that his analysis of the position in Australian shareholder class actions leads him to conclude that settlements in those actions in that jurisdiction have been reached for the benefit of at least 94,000 claimants, with mean and median figures of 9,000 Australian dollars and 12,000 Australian dollars respectively. So quite high participation for relatively small recoveries. Now, with respect, we say the judge erred in failing to pay sufficient regard to those factors and the evidence going to them. He said, first of all, that he was not deciding the case on policy grounds, but these factors, whatever they might be called, are clearly relevant to the exercise of discretion. And that's clear from both Lloyd and Commission recovery. So that was his first mistake in paragraphs 88 and 89 of the judgment. His second mistake was that he then mischaracterised the evidence before him as simply going to the preference of investors, which for reasons I've given is neither fair nor accurate. He also referred to the RBS rights issue and the Lloyds and HBOS claims, but they were different for the reasons I've indicated. And then he said that the position of the retail investors had been engineered by the funders, judgment paragraphs 98 and 99. And with respect, that too is neither fair nor accurate. Mr. Leadham, as we've seen, explains why a funder is not willing to fund retail investors in a multi-party proceeding.
Well, that's his assessment of the facts of the particular case. You're saying he's not entitled to draw that inference?
Well, with respect, no, on the basis of the evidence we've seen, which includes not just the evidence presented on these applications by Mr. Leadham and Mr. Lang and Ms. Mendoza, but by the experience, the real world experience from the other Section 98 claims.
But if I recall correctly, his point about engineering took into account the fact that these retail investors appeared effectively at the last moment, which might suggest that the funder, if you like, switched on the tap for them shortly before the hearing. Is that not the point he was making?
I'm not sure that it was. Paragraph
The
90,
judge said in 98,
98.
really, in a point that was echoed by my Lord Justice Nugee a moment ago, the retail investors are inexplicably not being allowed to participate in the multi-party proceedings because of the attitude of the funders.
And the answer to that, my lord, is the answer I gave a few moments ago, is that there is an explanation. And it would be irrational if it were in the funder's interest to fund smaller investors and retail investors in the multi-party proceedings for them not to do so. Why on earth wouldn't they? So it's all very well to try and say that it's a position that's been engineered by the funders. It's certainly that the position here reflects the position and experience as it has been more widely. And that should come as no surprise to anyone.
Yeah.
But in summary, the effect of the judge's decision in our submission is that 302 claims brought by 231 retail investors cannot be and will not be pursued. That they are not parties to the multi-party proceedings. And the same is likely to be true of other smaller retail and institutional investors who might otherwise have joined the representative class. So we do say that the representative action holds forth not just the prospect, but the likelihood of advancing access to justice for smaller investors who are effectively being denied the opportunity to seek redress. Otherwise, because for them, it is the representative action or nothing. That then leads me to the third topic, which I can take, I think, given the ground I've covered so far relatively briefly, which is that the case management objections to the representative action were not a sound basis for striking out the representative action and failing to permit the action to continue as a representative action. The first point here is one I've already made, which is that it was wrong for the judge conceptually to think of the representative action as ousting anything. The representative action is simply a different alternative procedure. And while the judge seems to have thought, or certainly this seems to be present in his approach and reasoning, that the multi-party action is some sort of default, and the use of the representative action some form of lesser alternative only to be employed if there was somehow some good or exceptional reason to do so. The true position on analysis in our submission is that the representative action is an available procedural tool which the representative claimant and the represented class can make use of, provided the jurisdictional threshold of same interest is met, as it is here, and unless there is some good reason to bring the proceedings commenced as of right and in accordance with the relevant rules to a halt. And the only reasons given are all reasons which would have arisen in Lloyd or Prudential, or at least to an extent in commission recovery. So the lack of individual particularisation of the stage 2 issues, the lack of advancement of the stage 2 issues, whether it be on the pleadings or disclosure or witness evidence, all of those issues necessarily would have arisen in the bifurcated proceedings contemplated in Lloyd, in the bifurcated proceedings in fact taken forward in Prudential, and in the bifurcated proceedings permitted in commission recovery. But the Supreme Court in Lloyd and this court in commission recovery did not regard the hiving off of the stage 2 issues to a later stage in the proceedings as an obstacle, still less some type of insurmountable or impermissible feature or difficulty which rendered the representative action as a whole inappropriate, justifying it to be struck out. And further, the importance of those case management considerations cannot, in our submission, sensibly be regarded as having greater weight than the fundamental purpose of the representative action, as explained in Lloyd, which is to widen the availability and efficiency of access to redress. And finally, to the extent that one does enter into this weighing of one procedural route against the others, that, so to speak, remains somewhat an exercise in speculation. No multi-party Section 98 group action has yet got to a stage 1 trial judgment. we know the advantages of the Lloyd type bifurcation identified in Lloyd itself. And we've seen how that has worked in commission recovery. And ultimately, in our submission, one struggles to identify the truly material point of distinction between the representative action that the representative claimant seeks to bring here and the representative action contemplated, endorsed and recommended in Lloyd, and in fact taken forward in Prudential. And with respect, it's only if some material point of distinction can be drawn between this claim and those that the judge's exercise of discretion to strike out the claim can begin to be justified. And we do say the effect of that decision, striking out the representative action, is to deny at least those 200 retail investors with their 302 claims a viable route to redress. So for those reasons, the judge misunderstood and misapplied the learning to derive from Lloyd. Having adopted the wrong starting point, he then gave too much weight to the case management considerations, such that in all the circumstances, his was an exercise of discretion with which this court can and should safely interfere to remedy the injustice caused by that decision. I think I've just about avoided an IT disaster with a microphone landing in my lap. And so if for no other reason than that, unless the court has any further questions for me, I'm going to sit down.
Thank you very much, Mr. Chapman. Yes, Ms. Lewis.
My lords, my lady. The starting point in relation to this appeal is that it is common ground that the learned judge was exercising a discretion that plainly exists under CPR 19.8, as confirmed in terms by the Supreme Court in Lloyd and Google at paragraph 75, and more recently by this court in Commission Recovery at paragraph 38, to determine that in accordance with the overriding objective, these claims should not be permitted to continue by way of representative proceedings. And in light of the existence of that discretion, it is obvious in our submission that there is no unfettered right on behalf of a claimant to choose the procedural manner in which it advances its claim. To the contrary, that is wholly unsurprisingly a matter which in the exercise of its discretion, the court is able to and should control in order to further the overriding objective. Nor, in light of the fact that it is a discretion to be exercised in accordance with the overriding objective, can there be, as a matter of principle, any presumption in favour of allowing a claimant to proceed in the procedural manner which it alone has selected, or a requirement that the defendant demonstrate some kind of knockout blow, as it was put this morning, or, as a further alternative that was put this morning, that the defendant identify some sort of structural deficiency in the use of the representative procedure. Indeed, any of those formulations would obviously constrain the court's ability to give full effect to the various requirements of the overriding objective, which necessarily require a multifaceted analysis of what is required in order to deal with any given case justly and at proportionate cost. Any of those formulations would involve the reverse hierarchy, as my Lady Justice Falk suggested to my learned friend, which would involve the claimant's choice being afforded greater weight than what the case requires in terms of justice and proportionate cost. And in our submission, There is nothing in either Lloyd or Google or this court's decision in Marks that there is any form of such presumption, whichever of the formulations one looks at. And it's quite clear that given the various considerations forming part of the overriding objective, the exercise of the discretion must depend on the particular facts of the case. Now, in this case, in the course of his careful and detailed judgment, very few paragraphs of which my learned friend actually addressed, the learned judge clearly conducted the very multifaceted analysis that the requirements of the overriding objective require, and concluded in the exercise of his discretion that in this case, in light in particular of the parallel existence of the multi-party proceedings and his analysis of the evidence relating to the position of the retail claimants, it was not appropriate to allow the representative proceedings to proceed. And indeed, he emphasised that he was exercising his discretion in that way in his judgment, refusing permission to appeal, which is in tab 10 of the bundle as well, and which I'm sure my lords and my lady have looked at. Now, in our submission, no error of approach has been or could be identified in relation to that analysis, and the decision taken by the learned judge was plainly one which was well within the generous ambit of his discretion. And it follows that in accordance with the well-established principles that we've summarised in our skeleton, which my lords and my lady will be very familiar, there is no basis on which this court should intervene. Now, I'm proposing to develop my submissions in relation to that by reference to the grounds of appeal that have actually been advanced, and by reference to the way that the judge addressed the various matters that are identified in the grounds of appeal. But before turning to do that, I just wanted to take a few minutes just to emphasise a few points about the nature of the claims that actually arise in this case, because that provides part of the key context to the consideration of the issues that arise. And I apprehend my lords, my lady are very familiar, but there are just a few further points I wanted to draw out. Of course, we all know that these, against my client, these are claims under Section 90A and Schedule 10A of FSMA, and the claims against my learned friend Mr. Patton's clients also include claims under Section 90. Now, so far as the Section 90A claims are concerned, there are 5 elements that any claimant seeking to establish such a claim must prove in order to succeed. First, standing. That is, that they have the requisite personality to sue and have acquired, held or disposed of the relevant securities. So that's a twofold test. Not just that they've acquired, held or disposed, but also that they have personality to sue. And we know from some of the other Section 90A claims that that has been a real issue in dispute, and that's led to disputed applications to amend and so on. The second thing they need to prove is that there is an untrue or misleading statement or omission in published information to the knowledge of a PDMR. The third, and this is significant, is reliance by the claimant on the information in question in deciding to acquire, hold or dispose of the security in question. Fourth, causation, that is, that they would actually have acted differently in the absence of the information. And fifth, of course, loss. Now, the importance of the reliance requirement in controlling the extent of claims that can be brought under this provision was very recently emphasised by Mr. Justice Leach in the judgment in the Barclays case, which my Lord, the Chancellor, referred to earlier. And that case is interesting because it provides a clear illustration of the sort of steps that can be taken in a multi-party action to prevent the pursuit of claims by those who do not meet the statutory requirements, which are simply not available in the representative proceedings in the form that they are put before the court in this case. And just to emphasise, my lords and my lady, in relation to that, for clarity, the ability of Mr. Justice Leach to see how much of the claim in Barclays was affected by the strikeout application came not from any sampling process, not from any disclosure process. It simply came from the fact that the claimants were required to identify which type of reliance they were alleging. Yeah. So it's a pure point of pleading at an early stage in the proceedings, which enabled my clients, Barclays, to identify that 60% of them were alleging only the price index reliance. And that then led to the strikeout application, which succeeded before Mr. Justice Leach.
Fraud on the market.
the fraud of the market. And that's an important point, because I'm going to come just in a moment briefly to show the court the pleadings and the multi-party action, because we've got the very same problem in these proceedings as confronted Mr. Justice Leach in Barclays. And whilst my learned friend referred a number of times in his submissions to the representative action operating as some sort of filter, which would protect the defendant, so seemed to be the implication, against claims being brought that are not even reasonably arguable, it is actually quite apparent that the representative procedure in this case is not operating in that way at all. And I'll explain to the court why that is in a moment. Now,
But I don't understand how that works really, because if you don't have to, if you proceed on the assumption that you don't have to produce anything by way of evidence of reliance, for example, then there's a sort of, you know, it's open sesame, isn't it really?
absolutely, and we'll come back to the cost and sharing governance agreement. The only information that anyone has to provide to sign up to the representative procedure is trading data, which, as I said a moment ago, doesn't even cover the whole of the standing question. It just simply covers whether there were shares acquired during the relevant period.
And remind us, the standing point is whether they are, whether the relevant alleged claimant is actually a legal entity.
A legal entity, or is the right party, because often in these Section 98 claims, there are pension funds where actually it should be the trustee who is claiming, rather than the pension fund itself doesn't have the ability to sue, particularly if you're looking at American entities. There's a whole range of reasons that those of us who have been dealing with these claims for a while now have seen that are being addressed in the context of standing, none of which is addressed by provision of trading data. It's by reference to who is the party who is actually the right claimant. And that led in the G4S judgment to there being a lot of claims being effectively, amendment applications being made which were not permitted because they weren't justified, the mistakes had been made by the claimant's solicitors and so on. And so the right people weren't claiming. The relevance of the fact that there are these 5 limbs to the claim is, of course, that the representative proceedings in this case are by definition only capable of determining one element of the 5 limbs, and they will therefore not lead to a determination of liability of the defendants as tool, as my Lord Justice Nugee put to my learned friend in the course of argument, where he referred to it being a determination of liability. That's not actually correct. It's only one element of liability. And it also means, to use my Lord Justice Nugee's language in commission recovery, we are by definition in the territory of the use of representative proceedings being less straightforward. And to be clear, I'm not making that point to suggest that it follows from the fact alone that only one element of the limbs that are required to establish liability can be determined, to say that the representative procedure could never be used. I accept, of course, as both Lloyd and Google and Marks make clear, that in principle it may be appropriate to adopt a bifurcated approach, such that only those common issues which can be dealt with are dealt with on a representative basis. But in our submission, it must be relevant to the exercise of the discretion that it is common ground exists in CPR 19.8, that it is necessary to adopt such a bifurcated approach, and considerations as to the extent of the bifurcation required must also be relevant in that context. Indeed, my learned friend came close to accepting that shortly before lunch, when in relation to the 8 points that he took from the authorities, Lloyd and Google, Prudential and Marks, was in the context of his suggestion that there needs to be some significant structural objection to allowing the representative procedure to be used. One of the points he said was that perhaps such a structural objection might exist if the common issues would not be sufficiently dispositive. That's precisely the point. Precisely the point, one must have regard to the level of bifurcation that is required and what the representative procedure will actually achieve in considering whether, when there are alternatives available, as there are in this case, and of course I'm going to come to deal with what my learned friend says about access to justice and what the judge found in relation to that, but where in our submission the judge rightly concluded there are alternatives available, one should be looking, by definition, at, well, what will the representative procedure actually achieve and what's going to be left over? And we would emphasise that Lord Leggett, in Lloyd and Google, was plainly not saying that in every case where a bifurcated approach was possible, it'd be appropriate to adopt that approach. To the contrary, in paragraph 81 of his judgment, he simply stated that there may be advantages in terms of justice and efficiency, nevertheless, in adopting such a bifurcated approach. But whether there are such advantages in terms of justice or efficiency must, in any given case, be affected by the extent of the bifurcation required. Not least because the greater the bifurcation, the less efficient it may be to adopt the split two-stage process. The delays associated with that approach may well themselves create issues in terms of justice, due, for example, to the loss of documents or relevant evidence, which itself could be prejudicial to one party. And of course, there is also the issue of whether it affects the court's ability to prevent the pursuit of unmeritorious claims. Now, those are all factors that are of particular relevance in this case. The claim form is summarised by the learned judge in paragraph 13 of his judgment at Core Appeal Bundle, tab 9, page 45. Where the learned judge set, page 45, paragraph 13.
13.
Yes. Where the learned judge sets out the forms of the declaration that the representative claimant seeks in the claim form against my client. And my lords, my lady will see that the claim is said to relate to information published from 2006. So some 16 years prior to the issue of the claim form. And so this is very much a case where delay in resolving issues could well lead to loss of documentation and evidence and hence prejudice. And as the learned judge noted in paragraph 14, this is an opt-in type of representative procedure, with those being represented not only needing to have acquired, held or sold the relevant securities, but also having been required to agree terms as to cost sharing and governance. So it's important to emphasise that this is not a classic representative action, such as that which was before this court in Commission Recovery, or indeed was being contemplated in Lloyd and Google, where the representative party is proposing to represent all parties interested in the matter in suit, no matter who they are or what their resources might be. I'm not saying that's itself a bar, but it is a feature of this representative action, and it's a feature that makes the standard cost sharing and governance terms that we have been provided with, and which my learned friend referred to after lunch, and I'll come back to, of some significance, because they do demonstrate that only parties with significant resources or access to significant resources can opt into the class if they have a claim of any size, but also that there is going to be proportionate cost sharing, so that if you have a small claim, your potential liability for costs is going to be very small. Now, we know, or we've been told, that every institutional investor party to the representative proceedings is a claimant in the multi-party proceedings. And that is the short reason why in our submission, the learned judge was entirely right to conclude that there was no access to justice issue in relation to the institutional investors in this case.
And some distinction was being drawn between larger and smaller institutional investors, but you're saying all.
I heard that distinction this morning, or during the course of my Learned Friends submissions today. As matters stand today, our understanding is that every single institutional investor that is party to the representative proceedings is party to the multi-party proceedings. And that's 286 institutional investors in numbers. And there's a list, should my lords, my lady be interested in it, in SAB's Supplementary Appeal Bundle 2 at tab 20, from which it's apparent they include a large number of sophisticated and large investors, all corporate.
Do we have any idea of the quantum of their claims?
I'm going to come to that because the answer is no, my lord. I'll pick it up now. The only thing we have been told about the quantum of any claim is what we were told in the letter before action, which is in the Supplementary Appeal Bundle 2 at tab 16. Paragraph 20 on page 388. So we inform you that we expect the number of claimants to increase, which will in turn increase the aggregate losses claimed. Ultimately, we expect the value of the investors' claims to be in the hundreds of millions of pounds. But that's it. There is nothing in the draft particulars of claim in the multi-party action, which was the next document I just wanted to refer to briefly, which are in the first supplementary appeal bundle at tab 9. I mean the second supplementary, I'm so sorry. Tab 15, sorry, second supplementary appeal bundle, tab 14 is my
Hang
class.
on, that's the first one. It is the first one.
First one, tab 14.
Draft particulars. of claim.
Yes, I apologise. Now, we've been provided with these in draft. They obviously haven't been served because the multi-party action was by agreement stayed pending the strikeout application. Although, as I indicated this morning, that stay will automatically be lifted if the appeal is dismissed. These particulars of claim are in identical form to the particulars of claim in the representative proceedings until we get to page 278. Where we have an additional section on reliance. And what the court will see is there's a plea that all the claimants reasonably relied on the published information. And then from paragraph 74 through to 76, there are 77, there are 3 different bases of reliance alleged. Paragraph 74, as one can see from the heading price and index reliance, is an allegation that the price of the shares was artificially inflated by the published information and or the untrue or misleading statements. And the claimants relied and they were induced to buy, continue to hold or dispose as a result of the price or the published information. So that's exactly the price index reliance allegation that Mr. Justice Leach in Barclays has just found is bad in law. And I should emphasise that that's also the view of Mr. Justice Hildyard in the autonomy litigation.
I'm going to say it comes from autonomy, isn't it?
Yes. So Mr. Justice Leach relies, he relies on a number of other things as well, but he includes it. So 2 first instance judges looking specifically at section 90A have said this is bad in law. And of course, if these proceedings were continuing, we would be entitled to apply just to strike out paragraph 74 to 75. There'd be no costs incurred in relation to any claimant only advancing that reliance until that strikeout had been determined. And if we're right, they wouldn't have a claim that would be capable of being brought. And then paragraph 76 on page 281 is interesting. Certain claimants relied on the published information and or the untrue or misleading statements. So it's quite clear from that description that it's a narrower group of the representative parties, but no indication given of how many.
Well, if you go back to 73, you can pick that up. All of the claimants plead they
Yes.
require continued, etc., on the basis of price or index reliance.
Yes.
So they all rely on that.
That, but only certain of them rely on direct or conduit
Indirect,
reliance.
some of them rely on direct.
And there's no indication of how many which. And my lords, we have asked in correspondence since the Barclays judgment whether they could tell us what percentage, and we've received no answer on the basis it's not relevant for the purposes of the representative proceedings. The other thing I draw out of paragraph 76 is a point that underlines the point I made about the difficulties of delay, which is one can see that when they are relying on conduit reliance, those claimants who are asserting it assert reliance not only on specific reports, but if one looks at subparagraph D and E, meetings, discussions with my client, meetings, discussions with financial analysts, and then F, participating in or reviewing transcripts. And those are all matters that in due course would need to be properly pleaded out and supported by evidence and assessed. But one of the complications of the representative procedure is that there is no opportunity to do that, and we would, if it were to continue, start on a standing start in relation to such issues whenever the representative procedure comes to an end, and whenever the claimants then decide how they're going to progress their...
Well, being realistic, the chances are, even if we allowed the appeal, and assuming the case doesn't go to the Supreme Court, the chances of getting a trial of the representative action on much before sometime early in 2026 are not great. Current state of the lists, both in Chancery Division and in the Commercial Court, which is after all its financial list case.
Yes,
And
absolutely.
in fact, Mr. Justice Michael Green heard it, but he heard it because there wasn't a Commercial Court judge available to hear it as a financial list judge. But I mean, I can't speak with absolute certainty for the Commercial Court, but I'm pretty certain their listing is pretty much the same as in the business list and the financial list, Chancery side. You wouldn't get a trial until early 2026.
My lord, the experience certainly of those on this side of the court would absolutely support that. Case management conferences have been held in other Section 98 claims in the last couple of months, and they're being listed in 2026. The first stage of any...
So then one assumes that, trial takes however long it takes, judgment sometime in the spring of 26 at the earliest. You're not looking at a stage 2 trial until sometime.
Well, spring
following year.
2027, they wouldn't be listed till 2026 in all likelihood.
No,
No.
then you've gone 20 years since the start date.
Yes, my lord. Now, my learned friend may say, well, some of the delay is occasioned by the fact that we've applied to strike out the representative procedure. And of course, I recognise that that's taken a year to get to this point. But that's not actually the key point here. The key point here is these are claims relating to information published and possibly meetings that occurred back in 2006. And yet the representative procedure that is being proposed means that only part of those claims would be determined in the first stage. And even if we hadn't applied to strike it out, you wouldn't be looking at a trial until next year anyway, so 2025. So the differential is not great. And the risks of loss of evidence and documentation, which are, and I'll come to it, part and parcel of the court's decisions as to how to case manage Section 98 claims, requiring some work to be done in relation to the claimant-sided issues, notwithstanding the fact that the trial is going to be predominantly directed to defendant-sided issues, such as those that were before my Lady Justice Falk in G4S and Serco. That's part of the reasoning for requiring that, and I'll come to it in due course.
Yep.
Now, of course, the fact in Barclays that a little over 60% of the claims by value are unsustainable in law on the basis of Mr. Justice Leach's decision obviously has significant impacts on the economics of the proceedings. And I will also come to it, clearly has significant impacts in relation to the prospect of settlement.
Yeah.
But, as I've already mentioned, on the basis of the representative procedures in this case, we don't know how many representative parties or claimants fall within the category of only alleging that type of price index reliance. We know they all allege it, but we don't know how many are only alleging that. And based on the material before the court, it seems very likely that the claimants don't know either. The whole purpose of the representative procedure in this case, as we've heard, is to avoid them having to spend any cost in investigating those sorts of matters. And if that's the purpose, it would seem self-evident that they haven't identified any of that material already. Indeed, they don't want to. That's what they're trying to avoid. And that's supported by the costs and governance arrangements that we've been provided with in tab 26 of the bundle. If we go back to those, in the supplementary appeal bundle, tab 26, page 462. From which it's possible to see at paragraph 6, which my learned friend referred to on page 463.
Sorry, for
Paragraph 6 on page 463. The information that the representative claimant and the representative persons were required to provide to their solicitors was solely valid, accurate and complete trading data. That's it. And then on joining, if one turns on to page 464, similarly, all one has to provide is valid, accurate and complete trading data. And that is, with respect to my learned friend's suggestion that the opt-in nature of these proceedings operates as some sort of filter, a matter itself of concern to the defendants in these proceedings, given the absolutely central nature of reliance to the statutory form of action. It was, of course, in that context that the learned judge, if we go to the judgment in tab 9, at paragraph 22, where the learned judge quoted the observations of Mr. Justice Hildyard in one of the first Section 98 claims, Manning and Napier and Tesco, and the learned judge, having quoted those, noted at the end of paragraph 22, Mr. Justice Hildyard's concerns about inadequate assessment of individual claims at the outset and joinder as a matter of subscription could be a description of what the representative proceedings in this case seek to achieve. And that's a precisely apt comment in our submission when one looks at the terms on which people are being permitted to participate. Now, as I've already mentioned, it's not only reliance that we have no information about. In fact, it's presently unclear what the total value of the claims is said to be, and nor do we have any information or any ability to obtain any information in relation to standing. Just while I'm on the point of the value of claims, a number of the submissions that were made to the court today appeared to be looking at matters prospectively, saying, well, if the representative proceedings are allowed to continue, it's to be expected that small institutional investors or other retail claimants might join. So far as the institutional investors are concerned, it could only be, any access to justice issue could only be a prospective one, because as I've said already, all of the institutional investors are signed up to both sets of proceedings, so it could only be. And so what seems to be being suggested is that the claimant and their funders should be entitled to use the representative procedures as some form of book building. Now, of course, that's a factor that would be in the interests of the funders, because no doubt the greater the number of claims, the greater the return to the funders. But it is of some note in our respectful submission that in the context of a group litigation order, it has been held that the possibility that a group litigation order will lead to more claims is not a legitimate reason for making such an order. If we look, for example, in the first authorities bundle at tab 7, decision of Mrs. Justice Asplin in the Tesco case at paragraphs 25 and 26. Sorry, we need to start at paragraph 22. One can see from paragraph 22 that Mrs. Justice Asplin was addressing a submission in relation to whether there will be any more claimants, which is one of the points that have been put forward to support the grant of a GLO in that case. And then at the end of the 25, she concluded it should be clear that any such approach is wrong in law as being the antithesis of what is required. What is required before such an order is made is that there is no other satisfactory means of resolving the dispute. And then if we also could look at Moon and Link Fund, which is in the second authorities bundle at tab 14. This time a decision of Mr. Justice Trower at paragraph 64.
Sorry, tab number?
14. Sorry. I can't read my own writing. 2 has become a 55. So I was intending to refer to Mrs. Justice Asplin at paragraph 55 back in tab 7. That's it. I do apologise. At page 152 of the first authorities bundle, where Mrs. Justice Asplin said, one does not make a GLO on the basis that to do so would be likely to attract a significant number of additional claimants, or for that matter to bring claimants out of the woodwork. As the masters in the case of Schmidt stated, a GLO should not be made for the sole purpose or predominant purpose of establishing a potential group of litigants. And that's the paragraph that Mr. Justice Trower in the Moon and Link Fund case then
Picks up at 64.
Picks up at 64, yes. Now, in our submission, the same approach ought to apply in relation to representative proceedings. Representative proceedings have very significantly less controls built into them than a group litigation order. In particular, a group litigation order needs to be, as is indicated by its name, something that is ordered by the court, at which time there will be a very detailed group litigation order covering numerous aspects of the claim, such as cost sharing, potentially whether it's going to be done by reference to test claimants and so on, but I'm sure the court is familiar with looking at them. They're very lengthy and they cover a whole range of issues. And as part of that, the court will scrutinise carefully matters such as the funding arrangements, ensuring that there is sufficient funding in place for the case to be conducted to an end, orderly joining up of claimants and so on and so forth. But if it's not appropriate to use a group litigation order to book build, in our submission, equally, it should not be possible to use an opt-in representative procedure to seek to do so either. There are nowhere near the same protections that are identified in the group litigation procedure in the context of the representative procedure. And that's not to say it's not a flexible tool that can't be used in appropriate circumstances. But if the argument is, well, if we can use this, we might be able to bring more claims in, that is when this aspect of it becomes relevant. And that did seem to be part of the argument.
Well, it's avowedly their case that if they're right, they are entitled to bring these representative proceedings as of right, and the court can't do anything about it,
And that will allow them to book build.
which would allow book building.
Because when we come to what is said about economics and so on and so forth, and in particular small investors, small institutional investors, as I say, there are no small institutional investors participating who are not already participating in the representative proceedings, who are not participating in the multi-party proceedings. So for those, that category of claimant, so insofar as my learned friend was making access to justice arguments, they must only be prospective ones in terms of allowing his funders to book build. And that's why I do draw attention to the fact, if that's not appropriate in the context of a group litigation order, one has to question why it would be appropriate in the context of representative proceedings. And that then brings me to the representative proceeding procedure, and in particular the first and second grounds of my learned friend's appeal, which is back in tab 3 of the core appeal bundle. In essence, my lords, as we understand my learned friend's submissions, he really only has 2 points. The first point is the suggested legal point about hierarchy of actions and the errors that the judge are said to have fallen into by reason of the fact he didn't identify strong grounds for stopping the action, structural defects, whichever way it's put. And the second is access to justice. The first part of that is covered by paragraphs 1A to B of the grounds of appeal, where there is a suggestion that the learned judge erred in law because the approach he adopted did not properly reflect or apply the decision of the Supreme Court in Lloyd and Google, as further explained by this court in Commission Recovery, in a judgment which of course postdated the judgment of the learned judge in this case. Now, with respect to my learned friends, we would submit that it is somewhat difficult to identify from their submissions precisely what error of law they are suggesting the learned judge made in this respect. What it seems to amount to is that, properly read, so it is suggested, Lloyd and Google requires the starting point to be that the representative procedure is a procedure that is open to a claimant if the same interest criteria is satisfied, and if the claimant decides to use that procedure, it should be entitled to do so unless, whichever one of the formulations, there's some good reason or there's a structural defect. In other words, there's some sort of hierarchical presumption in favour of the representative procedure. Now, it's to be noted, first of all, in relation to that, that the learned judge in fact rejected the submission that had been made to him by the claimants that there was some kind of presumption in favour of representative procedure, given that they could be started as of right. In paragraph 31 of his judgment, which is at page 49, starts at page 49 of tab 9 of the core appeal bundle. In the very last sentence, over on page 50, having referred to paragraph 75 of Lloyd and Google, he said that this is the same discretion as would arise under CPR 19.18.1b or indeed 19.9, and no presumption arises in favour of the representative proceedings by reason of their having been started as of right under CPR 19.8. Now, that's not a paragraph which my learned friend sought to take issue in his skeleton argument. Indeed, it's not referred to at all in his skeleton argument, and nor in our submission could he do so. The starting point is, as Lord Leggatt in Lloyd and Google emphasised, that the representative party procedure is a flexible tool of convenience in the administration of justice, which is to be applied as the occasion requires. That's what Leggatt said in paragraph 68. And of course, the background to the development of the representative procedure is, as Lord Leggatt explained in his judgment, that they were a means of mitigating the general rule that all persons materially interested in the subject matter of a suit should be made a party to it. So that's where it arose from. And if we take up Lord Leggatt's judgment in tab 12 of the First Authority Bundle, at paragraph 67, the point that Lord Leggatt is making in that paragraph is that given world developments, there are now numerous cases in which very large groups of people can be affected by legally culpable conduct, such that it is, as he says, even more important to reconcile on the one hand the inconvenience or complete impracticality of litigating multiple individual claims, with on the other the inconvenience or complete impracticality of making every prospective claimant a party to a single claim. So in other words, the representative procedure may be, depending on the circumstances, the only practical way to come at justice. And of course, those comments are understandable in the context of Lloyd and Google, which was a claim relating to 4 million iPhone users. But they do, in our submission, themselves demonstrate that what Lord Leggatt had in mind was that in appropriate circumstances, the use of the representative procedure could alleviate issues of inconvenience or complete impracticality of multi-party litigation. And that's an approach which in our submission itself necessarily implies that where multi-party litigation is neither inconvenient nor impractical, that is a matter which is to be considered as part of the determination whether or not to allow the representative proceedings to proceed. It, of course, being clear that the representative procedure is subject to control by the court in the exercise of its case management powers, which is the very point that Lord Leggatt was making in paragraph 75 of his judgment, and specifically emphasised in the context of a bifurcated procedure in paragraph 81. And there is nothing at all surprising about that in our submission. The court must always be in a position to control the use of its own procedures in furtherance of the overriding objective. That indeed is the whole purpose of the parts of the CPR imposing those as overriding objectives. Now, those paragraphs, paragraphs 75 and 81 of Lord Leggatt's judgment, also demonstrate in our submission why it would be quite wrong to treat Lord Leggatt as effectively saying that the court should be slow to prevent a claimant with an arguable representative claim from pursuing it. One just has to look at the language that Lord Leggatt used. He is expressly recognising solely that the representative procedure may be used, and then making it clear that whether or not it is appropriate to do so in any given case is a matter for the court's discretion. The first sentence of paragraph 81 is perhaps of particular relevance in the context of the use of a bifurcated process such as this case, because one can see from the language there that Lord Leggatt is saying that in cases where damages would require individual assessment, there may nevertheless be advantages in terms of justice and efficiency in adopting a bifurcated process, in effect recognising that if an overall claim is going to be split up in that way, it is necessary that there are such advantages in terms of advantages of justice and efficiency in the particular case which outweigh the benefit of proceeding with the claims as a whole. Now, of course, we acknowledge before the learned judge that in paragraph 75, Lord Reckitt highlighted certain aspects of the overriding objective and said that many of those were likely to militate in favour of allowing a claim, where practicable, to be continued as representative action. But equally clearly, Lord Reckitt was not saying that those aspects of the overriding objective would always lead to that conclusion. Indeed, in our submission, it is clear he was not seeking to prejudge the exercise by the court of its discretion in this respect, and would obviously have been inappropriate for him to do so. And one simply cannot draw out from either paragraph 75 or paragraph 81, which are the key paragraphs of the judgment relating to the discretionary element, any kind of presumption in favour of allowing a properly constituted representative action to proceed. Nothing along the lines, as my Lady Justice Falk put to my learned friend in relation to this, nothing along the lines of saying you need to have a knockout blow, nothing along the lines of requiring to identify structural deficiencies in the representative action. To the contrary, clearly and obviously appropriately expressed by reference generally to the overriding objective. And that, in our submission, is precisely what the learned judge did in this case. If we go back to his judgment, and it was his understanding of what Lord Reckitt was saying, and he was correct in that. If we go back to paragraph 42 of his judgment on page 52, at the end of paragraph 42, having referred to some submissions that I'd made, it seems to me that Lord Reckitt was simply making clear that the court needs to exercise its discretion so as to further the overriding objective, and that has to be done by reference to the particular circumstances pertaining to the case before it, which is not a conclusion based on Lord Reckitt's reasoning that is capable of any disagreement in our submission. And it's also clear that the learned judge nonetheless understood the significance of Lloyd and Google, in the sense that it made clear that in appropriate cases the representative procedure could be used, and indeed might be encouraged to be used, because if we look at paragraph 47 on page 53 of his judgment, the last sentence, he expressly stated that there was no doubt that Lord Reckitt wanted to see more use made of the representative action in the absence of class action rules, and for it to be a flexible method of getting such cases before the courts. So he wasn't dismissing, as seems to be inherent in some of my learned friends' submissions, Lord Reckitt's analysis in Lloyd and Google and diminishing it. He was accepting the significance of it, but rightly in our submission, recognising that in every case there is a discretion to be exercised in accordance with the overriding objective in determining whether or not to allow the representative procedure to go ahead. And to pick up a point that was put in argument to my learned friend, in our submission that discretion inevitably entailed the court, in this case, in weighing the pros and cons of the potential procedural routes which were available in relation to the pursuit of the claims. And that's the point that the judge is making at paragraph 48, the next paragraph of his judgment.
Yeah.
In circumstances where there are feasible multi-party proceedings available, it is in our submission difficult to see how an exercise of the discretion in accordance with the overriding objective could be conducted other than by reference to weighing the respective advantages and disadvantages of the potential procedural routes available.
Well, if you didn't do that, you'd be subject to an appeal.
Precisely.
On the basis of not taking all relevant considerations.
Precisely because the nature of the overriding objective is one that is furtherance of the administration of justice and efficiency. So one, by definition, needs to be weighing advantages and disadvantages.
Well, if the judge hadn't weighed that against the representative proceedings against the multi-party proceedings, you'd be appealing.
We certainly would, my lord. And, my lord, it's clear in other group claim contexts, such as GLOs or indeed collective proceeding orders in the Competition Appeal Tribunal, which are subject to control by the court, that what the court is doing at that stage, of course I accept their difference because there are specific regimes and one has to get permission to get a GLO and one has to get permission for a CPO. But what's interesting is what the court is doing is it's looking at the appropriateness of that procedure by reference to what other alternatives might be available. And that has to be the case because otherwise one simply cannot apply the overriding objective.
Yes, I mean, both of those types of procedures are actively case managed throughout.
Yes.
And I suppose the difference from representative proceedings is that there are more tools, obvious tools in the box for doing that.
There are specific tools specified in either the CPR in relation to group litigation orders or in the collective proceedings order in relation to the Competition Appeal Tribunal. What we submit, Lord Leggett was saying in paragraph 75 and 81 of Lloyd and Google, is that when it comes to deciding whether or not to allow the representative procedure to be used, the court needs to use the toolkit, which is the overriding objective.
Yes, well, I suppose there's only sort of one obvious tool, which is to knock out the representative claimant. Only one obvious route to achieving
well,
that, whereas there's perhaps more scope for a variety of outcomes in other.
I understand that entirely, my lady, although I would say, and I wouldn't take issue with the point that my learned friend made, which is in the context of the representative procedure, it may be possible, depending on the nature of the claim, to knock out part of it. So, for example, one of the points that was made by Lord Leggett in relation to Emerald Supplies, the conflict between the two groups of purchasers could have been resolved by only allowing the representation of some of the purchasers.
Yeah.
And I suspect that's where this idea of some sort of structural deficiency may have come from my learned friend. So that there may be, in permitting the representative procedure to continue, limitations that the court could put on it, which would be allowing something to go ahead, but in a different case. I'm not saying in this case, but in a different case. So it's not a sort of all or nothing necessarily discretion. It may depend, again, on the circumstances. Now, in weighing the respective advantages and disadvantages in this case, the learned judge, of course, took into account the various case management decisions that have been made in the other multi-party Section 90 and 90A cases, namely the various authorities he summarised in paragraphs 23 to 27 of his judgment, including the two decisions of my Lady Justice Falk in G4S and Serco. And whilst there is criticism of that approach by my learned friends, in our submission, that approach was also unimpeachable, not least because each of those other case management decisions were ones in which the court was also seeking to further the overriding objective by reason of the case management decisions that were being taken. And in particular, recognising that consistently with the overriding objective, whilst there should be a split trial, largely with the defendant-sided issues being determined at stage one, there should nonetheless be some progress made in tandem on claimant-sided issues for a number of reasons, and those included preservation of documents and evidence, first. Second, avoiding duplication of evidence in a situation like this one where you may have meetings being relied upon. Promotion of settlement, and I'll come back to that because the analysis of every first instance judge to date has been that requiring some progress to be made in tandem is likely to promote settlement, and complete bifurcation of the type that is being imposed by these representative procedures would not be the way of promoting settlement. And then also the more efficient progress of the proceedings overall, because of the absence of a standing start after stage one, and connected to all of that, minimising the potential for prejudice, which perhaps can be pithily summarised as my Lady Justice Falk observed in G4S, as trying to ensure an appropriate balance and fairness in the proceedings. And all of those were matters that the learned judge then took into account when applying the overriding objective. In this case, as the court can see from paragraph 101, for example, of the judgment at page 65. And in the present case, as the learned judge observed at paragraph 92, and as has been apparent from my learned friend's submissions to this court, the claimants are effectively being perfectly candid that the purpose of the use of the representative procedure is to avoid any prospect of the court taking those sorts of case management decisions in relation to the claim. They do not wish to run the risk of the court making orders that might require them to undertake some work, notwithstanding that the court would only be doing so if it thought it was appropriate to further the overriding objective. Now, with respect, that is not a particularly attractive position to be presenting, and in our submission itself underlines why it was clearly appropriate for the learned judge to weigh the respective advantages and disadvantages of the two available procedural routes for the claims that were before him. At one level, it is of course no doubt understandable that the claimants and their funders wish to minimise the work they have to undertake in order to commence proceedings. No doubt every single claimant before the English court would wish that to be the case. But there are two further features of the evidence before the learned judge that are important in this context. First, whatever the position might be as a matter of generality, it is quite clear that none of those considerations have led to any institutional investor declining to participate in the multi-party proceedings in this case. As I've already mentioned, every single institutional investor has signed up to both types of proceedings. So they are perfectly willing, if they need to incur the costs of pursuing the claims. They don't want to, but if they have to, they've indicated that they will do so. And so whatever might be the reluctance of institutional investors, whether large or small, to pursue multi-party proceedings in another case, due to the concern that the court might require them to undertake some work from the outset, that is not a consideration that is relevant in this case. And indeed, as the learned judge noted at paragraph 63, on page 57 of the judgment, my learned friend accepted before the learned judge that the evidence did not show that any institutional investor had been deterred from joining the multi-party proceedings in this case. I will come to the evidence of Mr. Lange and Ms. Mendoza, but in my submission, in that context, that is the short reason why that evidence is of no assistance, and the learned judge was quite right to give no weight to it. And the second point is a point I've already touched on, which is that what all this demonstrates is that what the claimants and their funders are seeking to achieve by the representative procedure is a situation in which claims are pursued without even the most basic of assessments as to whether in relation to each claimant there is any prospect that statutory requirements for establishing liability can be established. So in essence, what they are seeking to achieve is some form of free ride where they can pursue their claims against the defendants without any prospect of being required to address any issues as regards the validity of their claims from their side. And this is an important point. There is undoubtedly prejudice to a defendant being presented with claims which in fact have no merit, but which it is not in a position to ascertain until a considerable period down the track. Not least the risk of a claim of exaggerated magnitude being unfairly held over the defendant's head in order to seek to extract a substantial settlement in circumstances where there may be no proper basis for it. And that risk was something that actually the Supreme Court emphasised in its Merrick's judgment when emphasising the need at the outset of competition collective proceedings for the claimant to show a realistic prospect his proposed methodology worked.
Yeah.
It's at paragraph 154 of the judgment. I don't need to go to it, but it is a clear risk and a potential for prejudice for defendants. Now,
But it's part of what I think is described in, at least in one of the cases, as the court, the cat acting as a gatekeeper.
yes, and it's tied in with the point that Mr. Justice Hildyard was making in Manning and the Tesco case, and which the learned judge referred to in paragraph 22 of his judgment, that you don't have a gatekeeper approach. Now, if we go back to the grounds of appeal, back at tab 3 of the core appeal bundle, paragraph 1A, the first point that's being made is that one of the factors the learned judge relied upon in his analysis was the court's inability to case manage the claimant-sided issues from the outset. And indeed, of course, I accept that was a key part of his reasoning. But with respect to my learned friends, it's not correct to suggest that the learned judge treated that as some kind of bar to the representative proceedings. He clearly wasn't saying that. He was simply weighing up the respective procedures to determine which was appropriate in accordance with the administration of justice. The next point that's taken is that the learned judge started from the wrong premise that a multi-party claim is a default position. Again, that's an unfair characterisation of the learned judge's reasoning. To the contrary, what he was doing was noting the existence in this case of the multi-party claim and weighing the respective advantages and disadvantages. There's then a point about ousting the case management powers of the court. And I understand and obviously took on board what my Lord, the Chancellor, said in relation to the language. But the point that the judge was making was a simple one. He was making the point that in the context of the multi-party proceedings, the court has a whole variety of case management tools available to it in relation to the claims as a whole. Whereas in the representative procedure, the only case management tools that are available are in relation to the two common issues that have been identified in the claim form. And given that, as the judge correctly noted in paragraph 93 of his judgment, the only point of the representative procedure is to succeed at the end of the day in recovering compensation for the losses alleged to have been suffered by the representative persons. In our submission, it must be a relevant factor to the exercise of the discretion that in one scenario, case management of the claims as a whole can be undertaken, whereas in another, it's only case management of the specific common issues that are the subject of the representative procedure. Any other approach would be totally unreal in circumstances where, as in this case, there is no independent utility at all in the declarations being sought in the representative procedure, because they only form one part of the necessary ingredients of the cause of action. And in that respect, this case is somewhat different to the Commission Recovery and Marks decision, which my learned friend referred to, because if we go, I'm going to come to it in more detail, but if we go to, sorry, it's in the second authorities bundle,
Tab 23.
at tab 23. And we go to my Lord Justice Nugee's judgment at paragraphs 50 to 52 on page 618. In Commission Recovery and Marks, the core proposition being advanced by the claimant was that all that needs to be proved to establish liability are the fact of contracting on the standard terms of business and the fact of payment of commission. That was disputed, but then in paragraph 52, my Lord Justice Nugee pointed out that even if that wasn't right, and it was necessarily necessarily left over for further consideration were questions of disclosure, informed consent and limitation. It may be doubtful that how significant an issue those would be in practice, because it wasn't disputed that it was for a defendant to establish there's been sufficiently full disclosure, and so on, and it seems so on. So the facts in Commission Recovery and Marks were ones where the representative procedure may have gone a significantly further way down the line, had the case not settled, of resolving the claims than is possible in this case. Coming back to the grounds, ground 1A, tab 3 of the Core Appeal Bundle, page 28. The final point is that the learned judge wrongly treated representative actions as limited wholly or mainly to cases where access to justice would not otherwise be available to a class of claimants, or to cases where bifurcation is only in respect of damages. That, in our submission, is equally misconceived. It is clear from his judgment that the learned judge was not approaching matters on the basis that the use of representative procedures were limited in those ways. If we can start at paragraph 48 of the judgment on page 53, paragraph I referred to already, he was making the point that where there are perfectly feasible non-representative proceedings, the court should be able to weigh whether those are preferable, which, as I've already submitted, must be right, because it's a discretion to be exercised in accordance with the overriding objective. And then at paragraph 56, the learned judge returned to Lloyd and Google, made the point that the Supreme Court was advocating for greater use of the representative action, principally where it provided access to justice that would not otherwise be available to the class of claimants, and dealt with it in passing with bifurcation. What's clear from this passage is that the learned judge understood that the representative procedure was not wholly limited to cases where access to justice would be available. And it's equally clear, for example, from paragraphs 44 to 45 of the judgment, back at pages 52 to 53, that he understood that the representative procedure was not limited to cases where bifurcation is only possible at the damages stage. The short point I keep coming back to is that just because such a bifurcated approach is available in principle in such cases does not mean it is appropriate in every case. And the judge, in our respectful submission, was perfectly entitled to conclude, after careful consideration of all the relevant factors, that in this case it wasn't appropriate. Each case will inevitably turn on its own facts, and one cannot just leap, as my learned friend seeks to do, from the fact that there may be advantages in some cases to the conclusion that those advantages exist in every case, or indeed outweigh the disadvantages that are also inherent in the use of the procedure. And all that means it's a balancing exercise to be conducted in light of the overriding objective, which hasn't been in some way predetermined in the claimant's favour by Lloyd and Google. And that's the short answer, in fact, to the whole of grounds 1A and B on my learned friend's grounds, where they seek to try and identify an error in law by reason of a failure to misunderstand Lloyd and Google.
Yeah.
Before I leave the law, I should perhaps just deal with Prudential Newman, which my learned friends place much reliance upon. That was considered by the learned judge in paragraphs 49 to 51 of his judgment. Starting at page 53, tab 9. Where the learned judge is pointing out in paragraph 49, quite rightly on the facts, that Prudential was a very unusual case where the issue as to representation by the plaintiff of all other shareholders in their personal actions only arose at the beginning of the trial. and that Mr. Justice Vinelot was in any event going to try the underlying factual issues, both in the context of the plaintiff's own personal action and in the derivative proceedings. So by allowing the plaintiff to bring the claim, also in a representative capacity, this did not cause any disruption to the trial or require any particular element of case management. He then recognised that it was, of course, as is of course the case, that Mr. Justice Vinelot adopted a bifurcated process to enable him to bring into the trial the representative common issue. But at 51, having noted that it was influential in Lord Leggett's survey of representative actions about the possible use of a bifurcated process, concluded that it didn't really help on the question of case management and in particular when a decision has to be made at the outset of proceedings rather than at the trial itself. Now, again, we submit that analysis is perfectly correct when one looks at the facts of Prudential Assurance and Newman.
Yeah.
If we could go to the First Authorities Bundles, tab 4. Starting at page 34, 33 and 34. What one can see from the passage by G to H is that before the amendment application, which is the amendment application that Mr. Justice Vinelot is considering in the judgment my learned friend showed the court passages of, a case had already been pleaded that the circular was tricky and misleading and contained statements which the second and third defendants could not honestly have believed to be true.
So where is that?
As between F and G on page 33. And they've done that
Oh yeah.
as part of their derivative action. So they pleaded out that case as part of their derivative action. And then what happened is, as one can see if one moves on to page 34 between B and E, the second and third defendants tried at the beginning of the trial to prevent the action going forward on the basis that there was no basis for a derivative claim. And then on the 18th of June 1979, Mr. Justice Vinelot concluded that it wasn't necessary to decide the question because the plaintiff had made it clear that whatever the outcome of the derivative action, the plaintiff wished to pursue a personal claim against the second and third defendants for damages for conspiracy and would also seek on behalf of the plaintiff itself and as a representative to a declaration that the circular was tricky. And I emphasise the 18th of June date because if we go forward to page 58, which is
the third day of the trial.
Yes, it was the third day of the trial. What then happened was that there was an application to amend to insert precisely that claim, the representative claim. If we go forward to page 43, the judgment of Mr. Justice Vinelot is June 28th.
Yeah.
So in the middle of the trial, it's still in the first stages of the trial. And if we then go to the judgment of Mr. Justice Vinelot in relation to discretion at page 56, when Mr. Justice Vinelot at the bottom at page H was dealing with the argument that allowing the amendment would be to add numberless claims founded on fraud, and the court should be slow to admit the amendment, as it always is slow to allow an amendment alleging fraud, and which was rejected as being misconceived. The reason for that is that allegations of misconduct on the part of the individual defendants are made in the statement of claim. The effect of allowing the plaintiff to sue in a representative capacity is that if those allegations are proved, any member of the class will be entitled to rely on the judgment as res judicata. The amendment therefore doesn't add causes of action. It allows a common element in the causes of action of all members of the class to be established in one representative action. One can totally understand the appropriateness of allowing that to happen in the context of this case, in circumstances where the very issue, whether the circular was tricky or misleading, was already before the court in the trial. The judge was in the process of hearing the evidence and determining it, and it was appropriate to make that whatever conclusions he reached in relation to that, binding on a broader class. Now, that demonstrates a potential use of the representative procedure on a bifurcated way. But what one can't do in our submission is jump from that to suggesting, well, that establishes in some way, as my own friend sought to do in his submissions today, that case management consequences just aren't relevant. Well, they weren't. It would have been hopeless in prudential and assurance to raise the sorts of points that we are seeking to raise, and we did raise before Mr. Justice Michael Green in this case, because the issues were already before the judge, the evidence was about to be heard, and the issues were going to be determined. None of the points that the judge relied on and we relied on in front of the judge could arise, just by reference to the facts. A connected point is that my learned friend sought, in the course of his submissions, to draw assistance from the fact that in Lloyd, as he put it, there was no reference to the case management advantages of multi-party proceedings. But again, with respect to my learned friend, that is wholly unsurprising. Lloyd and Google was a case where there was no prospect of a multi-party action. 4 million individual claimants simply wasn't in contemplation. But nonetheless, what one does see in paragraphs 75 and 81 is Lord Leggatt emphasising the need to exercise the discretion in accordance with the overriding objective. And finally, in relation to commission recovery, that was another case where the choice was the representative procedure or nothing. There wasn't, so it's not surprising one doesn't see the case management considerations that the judge took into account in this case as being considered, because there wasn't an alternative feasible multi-party action on foot. Now, coming back to the grounds of appeal, paragraph 1b on page 28 to 29, the final point that is made is that in exercising its discretion under CPR 19.8, the court should have regard to the features of a bifurcated representative claim, which are apt to make it just and convenient for resolving common issues. Now, as a general proposition, I of course do not dispute that, but it is not a ground for criticising the learned judge in this case. He plainly considered in paragraphs 88 to 105 of his judgment the features of the representative procedure that was said to make it just and convenient as a means of resolving this dispute, but in the exercise of his discretion, he decided that in the circumstance of this case, those features were outweighed by the disadvantages of the representative process. Now, my lord, I was then proposing to move to the access to justice points, which are the next ground of appeal, but would that be a convenient moment?
Yes, I think so. Right. As you know, I can't sit tomorrow morning, so we'll sit at 2 tomorrow.
My lord, we're making very good progress.
I imagine we'll still go into Thursday, won't we?
Yeah, my learned friend Mr. Patton has some points he wishes to add at the end of my submissions. I think it would be optimistic to promise we can finish by the end of tomorrow.
I'm not pressurising anybody, I'm simply asking the question.
Yes. I doubt very much we will need the entirety of Thursday morning.
So 2 o'clock tomorrow.
Court rise in favour.